Emergency provisions. Key emergency provisions are contained in Part 18 of the Constitution, from Articles 352 to 360. These provisions enable the central government to meet any abnormal situation effectively. The rationality behind the incorporation of these provisions in the Constitution is to safeguard the sovereignty, unity, integrity and security of the country, the democratic political system, and the Constitution. During an emergency, the central government becomes all-powerful and the states go into the total control of the center. It converts the federal structure into a unitary one without a formal amendment of the Constitution. This kind of transformation of the political system from federal during normal times to unitary during emergency is a unique feature of the Indian Constitution. In this context, Dr. B.R. Ambedkar observed in the Constituent Assembly that 1. All federal systems including American are placed in a tight mold of federalism. No matter what the circumstances, it cannot change its form and shape. It can never be unitary. On the other hand, the Constitution of India can be both unitary as well as federal according to the requirements of time and circumstances. In normal times, it is framed to work as a federal system. But in times of emergency, it is so designed as to make it work as though it was a unitary system. The Constitution stipulates 3 types of emergencies. 1. An emergency due to war, external aggression or armed rebellion. 2. Article 352. This is popularly known as national emergency. However, the Constitution employs the expression proclamation of emergency to denote an emergency of this type. Point 2. An emergency due to the failure of the constitutional machinery in the states. Article 356. This is popularly known as President's Rule. It is also known by 2 other names, state emergency or constitutional emergency. However, the Constitution does not use the word emergency for this situation. Point 3. Financial emergency due to a threat to the financial stability or credit of India. Article 360. National emergency. Grounds of declaration. Under Article 352, the President can declare a national emergency when the security of India or a part of it is threatened by war or external aggression or armed rebellion. It may be noted that the President can declare a national emergency even before the actual occurrence of war or external aggression or armed rebellion. If he is satisfied that there is an imminent danger, the President can also issue different proclamations on grounds of war, external aggression, armed rebellion, or imminent danger thereof, whether or not there is a proclamation already issued by him and such proclamation is in operation. This provision was added by the 38th Amendment Act of 1975. When a national emergency is declared on the ground of war or external aggression, it is known as external emergency. On the other hand, when it is declared on the ground of armed rebellion, it is known as internal emergency. A proclamation of national emergency may be applicable to the entire country or only a part of it. The 42nd Amendment Act of 1976 enabled the President to limit the operation of a national emergency to a specified part of India. Originally, the Constitution mentioned internal disturbance as the third ground for the proclamation of a national emergency, but the expression was too vague and had a wider connotation. Hence, the 44th Amendment Act of 1978 substituted the words armed rebellion for internal disturbance. Thus, it is no longer possible to declare a national emergency on the ground of internal disturbance, as was done in 1975 by the Congress government headed by Indira Gandhi. The President, however, can proclaim a national emergency only after receiving a written recommendation from the Cabinet. 3. This means that the emergency can be declared only on the concurrence of the Cabinet and not merely on the advice of the Prime Minister. In 1975, the then Prime Minister, Indira Gandhi, advised the President to proclaim emergency without consulting her cabinet. The cabinet was informed of the proclamation after it was made, as a fait accompli. The 44th Amendment Act of 1978 introduced this safeguard to eliminate any possibility of the Prime Minister alone taking a decision in this regard. The 38th Amendment Act of 1975 made the declaration of a national emergency immune from the judicial review. But this provision was subsequently deleted by the 44th Amendment Act of 1978. Further, in the Minerva Mills Case 4, 1980, the Supreme Court held that the proclamation of a national emergency can be challenged in a court on the ground of malafide or that the declaration was based on wholly extraneous and irrelevant facts or is absurd or perverse. Parliamentary approval and duration. The proclamation of emergency must be approved by both the Houses of Parliament within 1 month from the date of its issue. Originally, the periodicity for approval by the Parliament was 2 months, but was reduced by the 44th Amendment Act of 1978. However, if the proclamation of emergency is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 1 month without approving the proclamation, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided Rajya Sabha has in the meantime approved it. If approved by both the Houses of Parliament, the emergency continues for 6 months, and can be extended to an indefinite period with an approval of the Parliament for every 6 months. This provision for periodical parliamentary approval was also added by the 44th Amendment Act of 1978. Before that, the emergency, once approved by the Parliament, could remain in operation as long as the Executive Cabinet desired. However, if the dissolution of the Lok Sabha takes place during the period of 6 months without approving the further continuance of emergency, then the proclamation survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved its continuation. Every resolution approving the proclamation of emergency or its continuance must be passed by either House of Parliament by a special majority, that is, a majority of the total membership of that House, and b. a majority of not less than 2/3 of the members of that House present and voting. This special majority provision was introduced by the 44th Amendment Act of 1978. Previously, such resolution could be passed by a simple majority of the Parliament. Revocation of Proclamation. A proclamation of emergency may be revoked by the President at any time by a subsequent proclamation. Such a proclamation does not require the parliamentary approval. Further, the President must revoke a proclamation if the Lok Sabha passes a resolution disapproving its continuation. Again, this safeguard was introduced by the 44th Amendment Act of 1978. Before the amendment, a proclamation could be revoked by the President on his own, and the Lok Sabha had no control in this regard. The 44th Amendment Act of 1978 also provided that, where 1/10 of the total number of members of the Lok Sabha give a written notice to the Speaker, or to the President if the House is not in session, a special sitting of the House should be held within 14 days for the purpose of considering a resolution disapproving the continuation of the proclamation. A resolution of disapproval is different from a resolution approving the continuation of a proclamation in the following 2 respects. 1. The first one is required to be passed by the Lok Sabha only, while the second one needs to be passed by the both Houses of Parliament. Point 2. The first one is to be adopted by a simple majority only, while the second one needs to be adopted by a special majority. Effects of national emergency. A proclamation of emergency has drastic and wide-ranging effects on the political system. These consequences can be grouped into 3 categories. 1. Effect on the center-state relations. 2. Effect on the life of the Lok Sabha and State Assembly. And 3. Effect on the fundamental rights. Effect on the center-state relations. While a proclamation of emergency is in force, the normal fabric of the center-state relations undergoes a basic change. This can be studied under 3 heads, namely, executive, legislative and financial. A. Executive. During a national emergency, the executive power of the century extends to directing any state regarding the manner in which its executive power is to be exercised. In normal times, the center can give executive directions to a state only on certain specified matters. However, during a national emergency, the center becomes entitled to give executive directions to a state on any matter. Thus, the state governments are brought under the complete control of the center, though they are not suspended. B. Legislative. During a national emergency, the Parliament becomes empowered to make laws on any subject mentioned in the state list. Although the legislative power of a state legislature is not suspended, it becomes subject to the overriding power of the Parliament. Thus, the normal distribution of the legislative powers between the center and states is suspended, though the state legislatures are not suspended. In brief, the Constitution becomes unitary rather than federal. The laws made by Parliament on the state subjects during a national emergency become inoperative 6 months after the emergency has ceased to operate. Notably, while a proclamation of national emergency is in operation, the President can issue ordinances on the state subjects also, if the Parliament is not in session. Further, the Parliament can confer powers and impose duties upon the centre or its officers and authorities in respect of matters outside the Union list, in order to carry out the laws made by it under its extended jurisdiction as a result of the proclamation of a national emergency. The 42nd Amendment Act of 1976 provided that the two consequences mentioned above, executive and legislative, extends not only to a state where an emergency is in operation but also to any other state. C. Financial. While a proclamation of national emergency is in operation, the President can modify the constitutional distribution of revenues between the center and the states. This means that the President can either reduce or cancel the transfer of finances from center to the states. Such modification continues till the end of the financial year in which the emergency ceases to operate. Also, every such order of the President has to be laid before both the Houses of Parliament. Effect on the life of the Lok Sabha and State Assembly. While a proclamation of national emergency is in operation, the life of the Lok Sabha may be extended beyond its normal term 5 years by a law of Parliament for 1 year at a time, for any length of time. However, this extension cannot continue beyond a period of 6 months after the emergency has ceased to operate. For example, the term of the 5th Lok Sabha, 1971-1977, was extended 2 times by 1 year at a time 5. Similarly, the Parliament may extend the normal tenure of a state legislative assembly 5 years by 1 year each time, for any length of time, during a national emergency, subject to a maximum period of 6 months after the emergency has ceased to operate. Effect on the Fundamental Rights. Articles 358 and 359 describe the effect of a national emergency on the fundamental rights. Article 358 deals with the suspension of the fundamental rights guaranteed by Article 19, while Article 359 deals with the suspension of other fundamental rights, except those guaranteed by Articles 20 and 21. These two provisions are explained below. A. Suspension of fundamental rights under Article 19. According to Article 358, when a proclamation of national emergency is made, the 6 fundamental rights under Article 19 are automatically suspended. No separate order for their suspension is required. While a proclamation of national emergency is in operation, the state is freed from the restrictions imposed by Article 19. In other words, the state can make any law or can take any executive action abridging or taking away the 6 fundamental rights guaranteed by Article 19. Any such law or executive action cannot be challenged on the ground that they are inconsistent with the 6 fundamental rights guaranteed by Article 19. When the national emergency ceases to operate, Article 19 automatically revives and comes into force. Any law made during emergency, to the extent of inconsistency with Article 19, ceases to have effect. However, no remedy leaves for anything done during the emergency even after the emergency expires. This means that the legislative and executive actions taken during the emergency cannot be challenged even after the emergency ceases to operate. The 44th Amendment Act of 1978 restricted the scope of Article 358 in 2 ways. Firstly, the 6 fundamental rights under Article 19 can be suspended only when the national emergency is declared on the ground of war or external aggression and not on the ground of armed rebellion. Secondly, only those laws which are related with the emergency are protected from being challenged and not other laws. Also, the executive action taken only under such a law is protected. B. Suspension of other fundamental rights. Article 359 authorizes the President to suspend the right to move any court for the enforcement of fundamental rights during a national emergency. This means that under Article 359, the fundamental rights as such are not suspended, but only their enforcement. The said rights are theoretically alive, but the right to seek remedy is suspended. The suspension of enforcement relates to only those fundamental rights that are specified in the presidential order. Further, the suspension could be for the period during the operation of emergency or for a shorter period as mentioned in the order, and the suspension order may extend to the whole or any part of the country. It should be laid before each House of Parliament for approval. While a presidential order is in force, the state can make any law or can take any executive action abridging or taking away the specified fundamental rights. Any such law or executive action cannot be challenged on the ground that they are inconsistent with the specified fundamental rights. When the order ceases to operate, any law so made, to the extent of inconsistency with specified fundamental rights, ceases to have effect. But no remedy leaves for anything done during the operation of the order even after the order ceases to operate. This means that the legislative and executive actions taken during the operation of the order cannot be challenged even after the order expires. The 44th Amendment Act of 1978 restricted the scope of Article 359 in two ways. Firstly, the President cannot suspend the right to move the court for the enforcement of fundamental rights guaranteed by Articles 20 to 21. In other words, the right to protection in respect of conviction for offenses, Article 20, and the right to life and personal liberty, Article 21, remain enforceable even during emergency. Secondly, only those laws which are related with the emergency are protected from being challenged, and not other laws, and the executive action taken only under such a law is protected. Distinction between Articles 358 and 359. The differences between Articles 358 and 359 can be summarized as follows. 1. Article 358 is confined to fundamental rights under Article 19 only, whereas Article 359 extends to all those fundamental rights whose enforcement is suspended by the presidential order. 2. Article 358 automatically suspends the fundamental rights under Article 19 as soon as